everyone. Good afternoon, everyone. I have to say, it is always true that moment between when I say good afternoon and people keep talking, I love that part because that means people are having conversations that are meaningful to them. And I hate interrupting, but we have a very good reason for that interruption. Thank you all for joining us today for the annual Ralph Fuchs Lecture. The Fuchs Lectureship in Law, it was established more than 20 years ago in the honor of Professor Ralph Fuchs. He was a distinguished and respected member of our faculty from 1945 until his death in 1985, which was just 2 years before today's esteemed speaker began his 35-year-long career as a member of the faculty of the Maurer School of Law. Professor Fuchs was an accomplished teacher and a pioneering scholar in the area of administrative law. But he was equally well known for his lifelong commitment to public service and for the dedication, creativity, and compassion that he brought to that work. And you will see in just a few moments why it is that we have invited Professor Kevin Brown to give this talk today, because he shared those qualities with Professor Fuchs. Professor Fuchs was the first chairman of the executive board of the Indiana Civil Liberties Organization. He was also active in the NAACP, and he was appointed to its State Committee on Legal Redress. He was deeply committed to defending the rights of free speech, free press, and free assembly in the university context, and eventually became the president of the American Association of University Professors. The yearly Fuchs Lecture, in many ways, is a cornerstone of a wide-ranging series of public service programs here at the Maurer School of Law, from the work done through our live client clinics and our pro bono projects, and through the hard work of our vibrant student organizations. Each year, as recognized at our annual Access to Justice sponsored awards ceremony, students provide thousands of hours of pro bono legal services, and we thank you so much for that, and it is absolutely the case that the communities surrounding us thank you for that work. Students receive no credit or pay for that work, and it is particularly valuable to those clients for that reason, so thank you. That work makes a tremendous difference to those who need legal services most. And public service is a critical component of a lawyer's life, and the Fuchs Lecture affords us an opportunity to learn how the law influences the public good. Past Fuchs lecturers have included some of the nation's top lawyers and legal scholars, all with deep commitments to public service. They include Sir David Williams of Cambridge University, William B. Gould, who is a former chairman of the National Labor Relations Board, Morris Dees, who was a civil rights lawyer and co-founder of the Southern Poverty Law Center, UCLA professor Ingrid Early, and Harvard Law School's Richard Lazarus, who delivered last year's Fuchs Lecture. This year's lecture is going to be delivered by Professor Kevin Brown. It is an honor to add him to that distinguished list. Professor Brown is Maurer School of Law's Richard S. Melvin Professor of Law Emeritus, having retired from our faculty in the summer of 2022. From 1987, when he joined our faculty, until he retired, in addition to his very influential scholarship, he taught thousands of students. His courses included basics like torts, and also closer to the subject of his lecture today, he taught courses in race and the law and courses that helped us understand the legal underpinnings of persistent inequalities in society, in addition to many other courses as well. When Professor Brown retired from Maurer, he did not retire in the way that most of us imagine retirement. He did not exhale and reflect on a long and rich and productive career. Instead, he was lured by the University of South Carolina's law school to join their faculty. So there, he is the Mitchell Willoughby Professor of Law. Students there are so fortunate to have his energy, his intellect, and his hard-earned wisdom in their hallways and in their classrooms, just as we are fortunate to still be able to call on him from time to time to share those qualities with us. I'm going to cede the floor to Professor Fuentes Rower, who is just one of Professor Brown's closest friends and closest collaborators on our faculty. In doing so, I want to acknowledge, though, Kevin, that so many of your colleagues would have loved to introduce you today, to honor you with a proper introduction to a room of students who predominantly don't know you anymore, but also to a room of colleagues who do know you and who love you and who miss you. We are all so happy to welcome you back. I am so glad you're here.
Good afternoon, everyone. I am tasked with introducing Kevin Brown, the Mitchell Willoughby Professor of Law at the University of South Carolina School of Law, on our very own Richard S. Melvin Professor of Law Emeritus for not long enough. The first thing I want to tell you is that I don't have enough time. And I actually spent my day yesterday trying to figure out what to tell you about Kevin, a person who many of you didn't get a chance to meet. You should know he went to Indiana University in 1978 and graduated with a degree, a Bachelor's of Science from the Kelley School. He went to Yale for law school, an '82 graduate, worked at Baker & Daniels, and then joined our faculty in 1987, the year I was born. Settle down. So what could I tell you about Kevin in my brief 25 minutes? He is a scholar. He's a scholar. He's published 2 books. And I quote, over 80 articles or comments on issues such as critical race theory, school desegregation, affirmative action, African American immersion schools, the impact of African Americans on the anti-apartheid struggle in South Africa, and the inspiration of the $250 million in India have drawn from African Americans, unquote. Kevin has taught all over the world, here in Bloomington, Austin, Texas, Tuscaloosa, Alabama, all the way to China, India, and the UK. He's received numerous awards for his teaching and his service. He has spoken on issues of race, law and education, and others on well over 100 occasions, including at the annual convention of the NAACP, the Congressional Black Caucus Brain Trust meetings, the American Bar Association, the National Bar Association, to the justices of the Indiana Supreme Court, and at several leading law schools, including Harvard, NYU, Virginia, Duke, Cornell, Northwestern, UCLA, and Texas. I really could go on, but I won't. Everything I told you, by the way, I cribbed it from our website, if you were curious. In my defense, a CV is 43 pages long. I didn't have the time. So rather than tell you any of that from a CV, I'll let you read it yourselves. So here's what I'm going to tell you that you couldn't get from our website. I could tell you that Kevin Brown is the best friend anyone could ask for. He's kind, he's funny, he's brilliant. He's an incredible world traveler. He's fun to be around, whether in Bloomington or Paris at a cafe, seeing tourists passing you by, or Bangalore, or Prague, or even the best city in the world, San Juan. Yes, Kevin is a big deal. And of course, yes, I confess, I am biased. But you get to decide for yourself. He's going to give you 25 minutes, then I hope the Q&A, push him. He should be pushed. And you will see he's an incredible guy, incredible person, incredible friend. I am so happy to see him again here today. Kevin, as always, great to see you. The floor is yours. Thank you.
When my longtime friend and good colleague, Dean Christy Ochoa of the Indiana University Myers School of Law, asked me to do a talk on affirmative action, I was deeply honored. I'm also immensely proud of Dean Ochoa, and quite frankly, I just like saying Dean Ochoa, because she's going to be such a great leader for our law school. And I want to be clear, I am still a member of the faculty of our law school. I retired, took emeritus status, I did not leave. Thus, I continue to be a member here. The title of my talk is The Consequences of the Harvard Affirmative Action Decision. Affirmative action was one of the major remaining race-conscious programs created during the desegregation era. The court's opinion in what I will call the Harvard Affirmative Action Decision marks the definitive closing of the final chapter of this era. With this decision, the Supreme Court has made it clear that we are effectively in the colorblindness era. So let's go back to the start of the desegregation era in the early 1960s. According to the 1960 census, 88.6% of all Americans were white and 10.5% were black. In other words, in 1960, 99.1% of Americans were either black or white. The Latinx community was determined and divided by race, not their ethnicity. So because I am rooting this conversation in the desegregation era, I'm going to primarily talk about the experiences of African American population, though not exclusively. After all, there would be no affirmative action programs for race and ethnicity had there not been slavery and segregation, which were principally directed at black people. But as a caveat, and though as someone who has taught about the experience of various Latinx communities in my race and law class, and as someone who spent over 20 months living and teaching in Asia, and over a year on the African continent, I've always been uncomfortable with the notion of thinking of all people of color as if they have the same problems. Nowhere else in the world have I encountered others who lump all of those who were former colonies of empires on the Iberian Peninsula together in one group. And nowhere else have I encountered the concept of lumping 60% of the population of America, 60% of the population of the world in Asia into one category. Indeed, this is a point Justice Gorsuch made in his opinion. Okay. Colorblindness is the doctrine that you transcend race, i.e. ignore it, in order to treat people as individuals. Now, colorblindness comes from individualism. And to be clear, colorblindness clearly has an important role to play in a society like ours, which is so racially and ethnically diverse. Indeed, it may be the only way that people across racial and ethnic lines can get to know each other. Many of my colleagues here I consider great friends of mine, Professor Dowschmidt, Professor Jerdigan, Professor Fishman. But I don't think of them as White Ken or White Don or White Rob, right? And I don't think of my good friend, Professor Luis Fuentes-Rohr, as PR Luis. But colorblindness does deny the lived experiences of people of color that are shaped by race. Simply put, you cannot understand Kevin Brown outside of understanding race. In addition, the implications of colorblindness are different when it is applied to educational, political, economic, and legal problems. The problem with colorblindness in these areas is that it will freeze into place the existing racial disparities. The origin of colorblindness comes from the opinion by Justice Harlan, who dissented from the 1896 decision of the Supreme Court in Plessy versus Ferguson. And for those of you who do not know what Plessy was, this was the Supreme Court's 8-1 decision that upheld separate but equal, and thereby gave the Supreme Court's imprimatur to the entire segregation era. Justice Harlan was the lone dissenting justice proclaiming, in what is perhaps the best known passage from any opinion ever written by a Supreme Court justice, our Constitution is colorblind and neither knows nor tolerates among its citizens classes of race. Justice Harlan was the only dissenting judge, and there's no question that the Black community in the early part of the 20th century was, when fighting segregation and racially conscious employment discrimination and racial disenfranchisement, argued for colorblindness. It was an obvious benefit given the total exclusion that was occurring as a result of segregation's legally accepted separate but equal, which of course in practice was separate but unequal. However, as many of you know, I was one of the participants of the original critical race theory workshop held in Madison, Wisconsin in the summer of 1989. There it is. And as you can imagine, not only have I written about CRT in the last 3 years, but I've delivered dozens of lectures about it. When discussing CRT, one of the things I always stress is that we came together the first time 6 months after the Supreme Court's 1989 decision in City of Richmond versus Croson. This is a decision where for the first time, a majority of the justices of the court found that strict scrutiny would apply regardless of the race of the beneficiary. Yet, the institution of the programs that strict scrutiny was now being applied to were all motivated by the desire to address the racial disparities that are inevitably a consequence of our history of racial discrimination. So let me quickly talk about Croson. Because see, when I was in law school in the late 1970s, we were taught that the Equal Protection Clause was there to protect discrete and insular minority groups from failures of the majoritarian political process. Majorities could simply pass legislation that would hurt minorities because of their legislative power. Thus, the Equal Protection Clause was a check on the tyranny of majority rule. But in Croson, the court indicated that it was embracing the concept that the Equal Protection Clause was there to protect individuals, not minority groups. This was the court seeking to embrace the colorblind interpretation of the Equal Protection Clause. So in doing so in Croson, it struck down a minority set-aside program for government contracting passed by the city of Richmond, Virginia, the capital of the old Confederacy, that set aside 30% of the prime construction contracts for minority contractors at a time in Richmond when 99% of those contracting dollars were going to white contractors in a city that was majority Black. The court concluded that even though 99% of the contracting dollars were going to white contractors, this set-aside provision for minority contractors was racially discriminatory to the white contractors. Go figure. And we at CRT did. By the time we came together in the summer of 1989, we knew about the racially oppressive side of colorblindness for the Black community when it was applied to educational, economic, political, or criminal justice issues, just to name a few. We knew that the colorblind interpretation would leave our society unable to address the massive socioeconomic racial disparities that still remain, because there would be no way to create and institute race-conscious policies that were going to be necessary to address those disparities. And thus, colorblindness was going to freeze into place the existing racial disparities that were the result of segregation and enslavement. The other thing that we knew about colorblindness was that Harlan's dissent was always taken out of context. When you look at the paragraph in Plessy versus Ferguson, where Harlan writes our Constitution is colorblind, go to the beginning of that paragraph, and it says, the white race deems itself to be the dominant race, and so it is in prestige and achievements in education, wealth, and in power. So I doubt not it will continue to be for all time if it remains true to the great heritage and holds fast to the principles of constitutional liberty. In other words, we at CRT knew what Justice Harlan knew back in 1896, that colorblindness would cement the racial disparities that we were worried about in place, possibly, as Harlan said, for all time. Since all of us at the original CRT meetings were either the only one or one of two professors of color at our predominantly white law schools, we realized that the Croson decision could threaten affirmative action programs at selective higher education institutions, including our own law schools. And eliminating affirmative action was therefore an existential threat to all of us. After all, such a decision would substantially decrease the paltry numbers of us who were teaching law and would devastate our black law student population by as much as a half, if not 2/3. Indeed, the most authoritative survey at the time put the figure at 3/4. Thus, it would be accurate to say that the primary motivation of CRT was to prevent the court's decision in the affirmative action case. In other words, CRT and affirmative action were wedded together at the very inception of CRT. And yes, that means I've been thinking about the end of affirmative action for nearly 35 years. Indeed, simply put, you could say thinking about the end of affirmative action has been the single dominant driving thought of my entire legal academic career. From the courses I taught, to the research I did, to the service activities that were most dearest to me. So because of that, let me simply give you, oh wow, yeah, I like that one. This was just so perfect, and this is how I feel. But because of that, let me give you the way we, as law professors, understood CRT. And I want to give you kind of the dominant driving rationale, because CRT really is not difficult to understand. Americans are well aware of the racial disparities that are so ubiquitous in family income, family wealth, access to health care, home ownership, incarceration rates, educational credentials, life expectancy. Is that enough? I can give you more. Occupational disparities, performance on standardized tests, neighborhoods negatively impacted by toxic substances, single parent family. I can give you more, but hopefully at this point you have the point. And we at CRT, we were aware of these disparities in 1989. Those disparities, frankly, have changed little in the last 30 years. And for us at CRT, the question was always, why? There should be little, if any, doubt that the disparities are traceable to the history of racial discrimination manifested in both enslavement and segregation. In other words, America has never been at a point where the socioeconomic conditions of the black community even remotely approximated those of the dominant non-Hispanic white community. Our fundamental given, our core idea was that the recognition that after long centuries of entrenched racial oppression during the time of enslavement and segregation, one of the major ideas in the dominant pantheon of American cultural beliefs, and by that I mean the ideas that all Americans are exposed to in our society on a consistent basis, is that black people in this country should have less. This is what we were attacking, because if we could not change that dominant idea that black people should have less, there would be no change in the racial disparities in the socioeconomic conditions. And this is not an idea that can be rooted out without a conscious effort to do so. Colorblindness does not allow for the development of the race consciousness needed to uproot this idea. And while the desegregation era saw passage of major civil rights legislation and the success of many highly visible Black people in different fields, it could not, it did not fundamentally alter the racial disparities and socioeconomic differences. Now, I could go through the various opinions of the majority and do a point-by-point refutation of the faulty inaccuracies and faulty legal analysis of the various opinions, but frankly, you don't need me to critique the faulty analysis. You have the dissenting opinion of a wise Latina in Justice Sotomayor and a wise African-American female in Justice Jackson to read. Besides, this is the sixth time in the last 20 years that the Supreme Court has addressed affirmative action. And the only thing that changed between the time it was upheld in Fisher 2 in 2016 and this time is the membership on the Supreme Court. All of Donald Trump's 3 appointees voted against upholding affirmative action, but 2 of those replaced former supporters of affirmative action. So instead of a 5-4 decision upholding it, you get a 6-3 decision striking it down. And once again, as Justice Sotomayor pointed out in her dissent, all the arguments advanced by the majority to justify striking down affirmative action had been rejected by the court prior to this opinion. Now, for most of us who've been advocates of affirmative action, and I truly believe my next statement reflects the beliefs of at least 80% of the African-American legal academics. We have always worked with an unstated assumption that we disagreed with, but we accepted. We believe that the reason Black applicants don't look as strong in the admissions process is not the shortcomings of Black individual applicants. It is the shortcomings of our society's concept of merit, which were developed during a period of time when we were excluded from predominantly white institutions. It is the shortcomings of our society then, not the problems of Black applicants, that make them look not as strong in the admissions process. Now, I should point out, though, that the court's opinion does not reject diversity. It only rejects the consideration of race and ethnicity, something it derisively calls facial diversity. Thus, the court doesn't disagree that admissions committees can know about an applicant's race if the applicant discloses that in a personal statement. And admissions officers can take into account their racial struggles if they demonstrate non-racial characteristics like determination, courage, willingness to confront injustice, and the like. And this is what we as African Americans always believed was the case anyway. That is precisely why we thought you needed to take into account race in the first place. Now, what I want to talk about is what this decision will mean going forward. But I got to preface these remarks because seeing into the future is like trying to see around the corner. You don't know what the unexpected development is approaching because it's hidden from your view. In addition, Supreme Court opinions dealing with race are often met with massive resistance that undoes much of their effect. For example, in 1857, the Supreme Court in Dred Scott effectively legalized slavery throughout the entire country. And the northern states that did not want it rejected compliance with it until the Civil War. In 1880, in Strouder versus West Virginia, the Supreme Court said you are not to discriminate against people when it comes to jury selection. And yet for the next 80 years, we watched how prosecutors and defense attorneys got around this prohibition against racial discrimination of Black jurors. And in 1915, in Buchanan versus Worley, the Supreme Court addressed the city of Louisville ordinance that zoned neighborhoods into race. This will be a black neighborhood, this will be a white neighborhood. The Supreme Court struck that down, and the real estate industry then developed racially restrictive covenants that were placed in the deeds of individual white homeowners that accomplished the same thing. And of course, in 1954, the Supreme Court in its Brown versus Board of Education decision struck down segregated schools. And let's face it, the massive resistance to school desegregation is simply legendary. So thus, I agree that the impact of the end of affirmative action is still to be determined. Yet some things are clear, because after all, Supreme Court decisions do have their consequences. The desegregation era has come to a final end, and it did spark amazing progress. The progress, however, was not simply attributable to color blindness. It also required the color-conscious programs like school desegregation, like affirmative action, like DEI programs, like protection of minority voting rights. These measures were manifestations of what Supreme Court Justice Harry Blackmun succinctly stated in his opinion in the Bakke case: in order to get beyond racism, we must first take account of race. There is no other way. And in order to treat some persons equally, we have to treat them differently. In the discussion of what the court's affirmative action decision means, I know I'm addressing three different audiences here. First, I'm speaking to my colleagues. And my colleagues here at this law school are truly an incredible collection of individuals. I would be proud to have them teach my own son. Indeed, they did. He's a 2019 graduate of the Maurer School of Law, and let me be clear, this was not the cheap alternative. Okay? He didn't receive much in scholarship. I understand the negative consequences of the court's decision, but like all Supreme Court decisions, there's clearly an area of interpretation involved in its application. If you, my colleagues, want to do anything for me because of what I meant for this institution, what I would urge you to do is to interpret that opinion as broadly as possible to maximize the number of Black and Latinx students that you are able to enroll in the future. I would also urge you to be particularly considerate of the experiences of the Black and Latinx students in the student body now. While we know that all non-traditional students feel anxiety about attending law school, for these students, the ground has just shifted under their feet. They will carry an extra burden that no other law students in the history of our law school will have to carry. Now, because they are the ones most affected by this decision, I want to next address the Black and Latinx students. Having been a law professor here for 35 years, I had the privilege of being the professor here during the time that 85% of the Black and Latinx students that have graduated from Maurer were students. That means I've seen the legal careers of so many Maurer alums of color ultimately unfold. To the current Black and Latinx students, let me be clear, however you view yourselves now, I know that in the coming decades, you're going to be the leaders of your communities. It also means when it comes to standing up for disadvantaged communities, you're going to be at the front of the line. But the future of your entire life has been changed by this court decision. I feel your pain. I want to apologize that we, meaning scholars who focused on issues of racial equality, could not have done more to prevent the Harvard decision. But as I pointed out, one of the major reasons for CRT was created 35 years ago was to prevent this decision. So make no mistake about it, the court's decision did not result from any lack of effort by the Black and brown legal communities and our so many white allies. While I cannot speak for your fellow students, I can say that the administration, faculty, and staff of this law school will be immensely supportive of students of color. You have allies among the faculty. But as I have said, and I say this not only as a faculty member, but once again, recall, my son was a former president of BOSA. So I can also say this from the knowledge I gained from his being a student here. But as I have said, Supreme Court opinions have consequences. And this is a law school, and a law school must follow the law. That means that things are going to change in ways that you and I are going to find very disagreeable. But the blame for these objectionable changes does not lie with the administration, the faculty, or the staff. It lies with the court. And to the Black and Latinx students, I must also give you some advice. But before I do, I need to pave the way. You see, normally for us as Black people, especially as African Americans, we don't speak about what it is we truly think about racial issues in mixed companies. So yes, I say different things when I'm in front of a predominantly Black audience as opposed to being in front of a mixed audience. But this is the forum I have. And I either decide to speak candidly in a mixed forum or not at all. And my obligation to you is that I do the latter and not the former. Now, I could try to sugarcoat it. I could try to minimize the impact. I could be equivocal, but that would be a disservice to you. Sometimes it's better to hear the truth, the hard truth, so that you can do what you can to guard against it. For all 3 years of Black and Latinx students, and particularly for the first year Black and Latinx students, your academic performance will be scrutinized for decades to come. It will be examined more than the performance of any group of Black and Latinx students since the earliest days of school desegregation, 60 years ago, and maybe even more. Commentators, scholars, researchers, academics, and politicians are all going to want to discern the effects of affirmative action. And the most obvious measure is to compare the academic performance of the students of color who enrolled during the affirmative action period to those students of color who will enroll in the post-affirmative action era. This is especially true for the first year students because you provide the bright line that separates the two. And in the battle of what affirmative action meant, it will mean one thing if there's no discernible difference between your academic performance and the post-affirmative action students' academic performance. But it will mean something totally different and far more negatively if your performance is worse. While the court struck affirmative action, the one thing that we know is that changes in court personnel can change court opinions. Precedent has been and can be overturned. But in the decades to come, a primary piece of the evidence for overturning this decision will be the academic performance of the students of color who are on affirmative action now. So if there's any possibility of reversing the court's decision 20 or 30 years from now, a significant part of that evidence will be your performance. Look, I hate to do this to you. Simply put, you have to carry the weight. I know it isn't fair. I know that you may believe that you shouldn't be the ones to bear the burden. Heck, some of you might even not identify with the struggle. but the struggle identifies you, and that is just simply something you are powerless to change. The confluence of events have put you in this position, so if you care about your people, if you want to make a major contribution, then do it now. Do your absolute best on your academic work, and by that I don't just mean classes and participating in classes. I mean write on the law reviews, participate in moot court, seek leadership positions in student organizations, make your presence memorable. What this decision means for American society then, this will begin a period of disengagement at the highest levels of our society between black people and the dominant white community, especially at the highest level of legal, academic, and the corporate worlds. First thing, before I talk about the impact, is to keep in mind, and it's critical to keep this in mind, major areas of racial oppression were accompanied by belief systems that made the forms of racial oppression appear to be the natural order of things. During chattel slavery, dominant American society did not think that slavery was wrong. They had explanations and justifications that made it seem as if that was the natural order of things. And during segregation, it wasn't dominant American culture that viewed segregation was wrong. It was accepted that segregation was the natural order of things. And now that we're in the colorblindness era, the continuation of the idea that black people should have less will also be understood as part of the natural order of things. One possibility is the strengthening of the notion that it is the fault of racial minorities that they don't do better. A classic blame the victim. But that will be a very troubling path for black people. However, given the colorblind belief system discourages thinking about racial and ethnic groups, I suspect that there will be a conscious effort to reduce the collecting and reporting statistics demonstrating racial disparity. After all, we only started keeping those statistics in the 1960s because we wanted to point to the existence of the disparities. But a natural way to make racial disparities cease to exist in the colorblind era is simply not to generate the statistics that reveal the disparities in the first place. You can imagine what would happen in a second Trump administration to the federal government's desire to produce racial statistics. Regardless of whether the statistics are generated or not, the racial disparities that exist in the important socioeconomic factors will be frozen in place. And by that I mean for generations. There will be a significant reduction in the number of black people who benefit from selective higher education. Because of this reduction, there'll be a reduction in the focus on the perspectives of Black and Latinx communities throughout American education, from kindergarten all the way to law school. For example, you'll see the gradual disappearance of race and law classes. After all, they only came into being because you had black professors. You will also see attacks on DEI efforts. And there will be fewer and fewer black people working at the highest levels of society, including large law firms, accounting firms, corporate officers, and academia. The reduction of black people in academia will mean that the perspective of black and brown people about American society, American history, will wane. As I said, after all, I was the one that created the first race and law course here. But as black academics at selective higher education institutions deal with the reality that there are fewer and fewer of them joining the faculties of these institutions and a significant reduction in the number of black students, some will seek to head to faculties at HBCUs. So I expect a renaissance of the education at HBCUs. A much larger percentage then of those with some African ancestry who will attend selective higher education institutions will either be mixed raced or first or second generation Black immigrants. In other words, over time, you will see a very small percentage of Black people in selective higher institutions whose entire ancestry comes from segregation and slavery. As an example, I truly expect in the next 10 years, if it hasn't happened already, that a majority of the undergraduate degrees at Indiana University that go to Black people will go to mixed race Black people or first or second generation Black immigrants. We'll also see the alliance of people of color, especially the Black and Latinx, will suffer. We will continue to cooperate for political reasons, but cooperating for political reasons is not nearly as important as cooperating for social justice reasons. Few people seem to realize there was a Supreme Court's 1971 decision in Keyes versus School District Number 1 where the court united the struggle between Black and Latinx communities. In that opinion, a major school desegregation opinion, the court said, "We conclude that the district court erred in separating Negroes and Hispanos for purposes of defining segregated school. There is much evidence in the Southwest that Hispanos and Negroes have a great many things in common. And one of those things in common is economic and cultural deprivation of both groups." And then finally, I don't think this will happen, but in times of great despair, Black people always turn back to Africa movements. That happened in the 1850s, it happened in the 1920s, maybe 20 years, it may happen again. So in conclusion, I want to conclude by making one last remark about the end of affirmative action. Because you see, today I plan on going and seeing my picture that's hanging up on the wall for the first time next to my good friend Earl Singleton, who's the other Black person whose picture is there. And he and I are the only two that have served for 25 years and retired from Mauer, that is, long enough to get our pictures up there. But when I think about the post-affirmative action future in my picture, I can't help but wonder if over the coming centuries, there will ever be another Black person's picture that'll go up on that wall. I seriously doubt there will be another one in 100 years. Thank you for giving me this opportunity to talk to you.
Well, I sincerely hope that there will be more pictures on that wall.
I do too.
But there will not be another Kevin Brown. So thank you for, truly such a thought-provoking and beautiful lecture that gave us a lot to think about. I need to handle a few logistical details, which is to let those of you who are seeking CLE credit know that the CLE code is 42183. Again, that's 42183. Second, I want to just state that our law school typically has a lecture to mark Constitution Day, which is the anniversary of the signing of the Constitution, which I believe is September 17th, technically. And we decided, since we knew that Professor Brown was coming and was going to be delivering this lecture on this topic, that this would also be our Constitution Day observance. And boy, was it a good one. And with that, I'd like to invite you to go ahead and ask questions. We have about 10 minutes or a little less than 10 minutes left. If you could just come up to that standing mic so that those who are watching on Zoom, and we do have many people on Zoom, including many alums who got to learn from Kevin directly, hear the questions. So please go ahead and come up to the mic and ask questions. Don't be shy.
Yeah, I can't understand. It would be difficult.
Can everybody hear me? All right, Professor, I just want to once again thank you for this lecture. This was incredible and very illuminating. I'm curious about the various forms that affirmative action takes and how that affected movements for and against it. So I guess in the post-Bakke world, where schools focus less on quotas and more on the holistic diversity approach, do you think that made it easier for courts and movements against affirmative action, or do you think it made it harder to single it out?
Let me do it. It's a great question, but I'm actually going to take it in a totally different direction.
Go ahead.
And the reason I'm going to take it in a totally different direction is because just like Harlan's dissent in Plessy, people look to Powell's opinion in Bakke and go, okay, we can cheer this. But think about what happened in Bakke. Here's the medical school going, we've excluded people of color. We normally have 84 people in our first year class. Let's make 16 because that's the percentage of people of color in the society, and we'll reserve 16 of those spots for people of color. Quotas. And four of the 9 justices said quotas were fine. Imagine where we would be, how different this society would be if for the last 50 years we had 12% black students graduating from law school, from business schools, from medical schools. What that would have done would have eliminated the very racial disparities that I'm talking about. So Powell's opinion in Bakke becomes the first significant decision by the Supreme Court to cut back on what were these programs and policies that the American people had embraced and were moving forward to try to overcome the racial disparities. But frankly, no, I had to say, I really had to say, I am astonished at how much pushback there has been against affirmative action. It's not like Americans don't know that the racial disparities are rooted in the past of slavery and segregation. And when you look at our percentages, that's what happened with Bakke. Well, Bakke would have been 12% if it's quotas. Now it's 4 to 6%. With this decision, 2 to 3%. And it, to me, it's just unbelievable that people would focus on us and go, we're the problems when we've been the victims for, 400 years? I'm sorry, I should stop.
Thank you.
I will say this. I was so depressed after the opinion. This is the first time, this is probably going to be my only time really talking about it, because this is not a message I like to deliver. But if I was going to deliver it, this was the one place I wanted to deliver it at. So, thank you, Dean.
Professor Brown. Any more questions? We probably have time for 1 or 2 more questions.
Hi, Professor Brown. I remember sitting in your office hours a few years ago and you discussing your research on caste discrimination and the problems of caste in America, especially with your work on the Dalits. And how do you see this decision in effectively creating a caste system in America and tying into those concerns that you've had and have discussed with your students?
Well, let me just only because you mentioned it. So I'll continue with my work on caste and the Dalits. So just last week, the California legislature has now passed legislation to make caste a protected category. And a lot of it's built on the research which I did of the connection between the concept of caste and America's creation of its anti-discrimination legislation. Because for us, our anti-discrimination legislation, which starts in 1866 with the Civil Rights Act of 1866, was an intent to prevent a caste system. So I just had to get that out there because I'm still involved in that work. you know, America's caste system, I'm going to say two things. One thing, because I've traveled so extensively, and there's no question, I do believe that black people in America are oppressed. I do believe that. But when I look at other systems of oppression throughout the world, they're much worse than what we look at here in the United States. India's system of oppression based on caste is one that I can't imagine they're going to overcome for 1,000 years. When I was in South Africa and looked at the treatment of the black majority, they won't get to racial equality. Well, they won't get there. The gaps that they're dealing with are so huge. In America, I think there is more freedom and flexibility. And the push with this individualism, which is something everybody ought to be concerned about, is it says to individual black people who become successful like me, you don't have any obligation to help the rest of them. And you know, if you look at black people who are successful and they're not helping other black people, everybody else is going to go, well, why should we help them too? So yes, I'm worried about that too. So let me stop there.
Thank you so much.
Look at that. It is perfect.
Oh,
timing.
1 o'clock. Okay.
We could stand here and talk for a whole lot longer, but please join me in thanking Professor Fuchs.